Can a landowner evict a mining right holder after lease expiry, especially where a sale is pending? Today, we analyze the Supreme Court of Appeals judgment delivered in February 2026 in the case of Zincede Ngokwakho Housing Private Limited versus Matatiele Local Municipality. This ruling provides critical clarification on the coexistence principle and the legal survival of mining operations during land transfers. Hi everyone, and welcome to the SAminingDesk. At the core of this case are three fundamental legal questions. Does a mining right allow access to land in the absence of a valid lease? Can lease rights linked to mining be transferred without the landowner's explicit consent? Does the intention to sell the property override the statutory rights of a miner? These questions sit at the volatile intersection of property law, administrative law, and the Mineral and Petroleum Resources Development Act, MPRDA. To analyze the judgment, in this video we will discuss background and the fact of the case, the legal framework relied upon by the court, the judgment and reason of the court, summary and key takeaways. Let us begin with background and the facts of the case. The dispute originated over municipal land where mining activities were taking place. Zincede Ngokwakho, referred to as ZNH, was granted a mining right in 2012 in terms of the Mineral and Petroleum Resources Development Act 2002, referred to as the MPRDA, for a period of 10 years, expiring in May 2022, to mine gravel on land owned by the Matatiele Local Municipality, referred to as the Municipality. ZNH and the municipality were engaged in a legal battle which resulted in a settlement agreement between the parties in 2016, which led to a lease agreement. The lease agreement matched the duration of the mining right and provided for an option to renew on conditions such as a 6 months notice to renew prior expiry by ZNH, municipal council ratification, among others. In 2020, the mining right was transferred to Stonewell Quarry Private Limited, referred to as Stonewell, and the transfer was approved in terms of Section 11 of the MPRDA by the minister. Stonewell took occupation of the land and continued mining operations. Crucially, while the mining right was formally transferred with ministerial consent, the lease agreement with the municipality was not explicitly re-signed by the new entity, Stonewell. By 2022, Stonewell had applied to renew the mining right to the department. In terms of the MPRDA, whilst a decision is pending on the renewal application, the right remains valid. At the same time as the original lease term approached its end, Stonewell sought an extension and issued a notice to extend the lease to the municipality. The municipality refused, citing a decision to sell the property, and issued a notice to vacate. Stonewell refused. Litigation followed in the High Court, KwaZulu-Natal, Pietermaritzburg. The High Court ruled in favor of the municipality, declared no valid lease exists, ordered Stonewell and ZNH to vacate the land, required rehabilitation at their cost. The courts reasoned that a mining right alone does not justify continued occupation without a valid lease. Stonewell and ZNH were aggrieved by the High Court order and took the matter to the Supreme Court of Appeal, SCA. In coming to a decision, the court considered a variety of legal frameworks, but at the core of the consideration are the following. The MPRDA. Section 5.3 of the MPRDA outlines the rights of mining right holders, including right of occupation, among others. Section 11 of the MPRDA deals with transfer of rights with consent of the Minister of Department of Mineral and Petroleum Resources. Section 54 of the MPRDA, internal remedy for when mining right holders are denied access to the land. The court also considered case law, including the Constitutional Court judgments in the case of Maledu versus Iterelling Bucket Lachlan Mineral Resources, which emphasized that law requires both the landowner and the mining right holder to exercise their respective rights alongside each other to the extent that it is reasonably possible to do so. This requirement fosters a situation where the rights of the landowner and the mining right holder coexist. The court also considered Banyana Melita minerals versus Genora Resources, which held that mining right applicants must consult landowners to see if reasonable accommodation between the parties is possible. These cases establish a foundational principle: landowner rights and mining rights must coexist and be exercised reasonably alongside each other. Judgment in reasoning. It is important to note that the SCA delivered two judgments in this case: the majority judgment by Ngokwakho ADP with Weiner JA and Chile AJA concurring, and the minority judgment, Bartman JA with Stein AJA concurring. Both judgments reached the same outcome, which is the appeal was upheld, the eviction order was set aside, and the municipal application was dismissed. It is equally crucial to note that while the outcome was similar, the legal reasoning of both judgments differed significantly. The majority judgment, which is the binding precedent and the law we must follow, took a more contractual and cooperative view, whilst the minority judgment focused mainly on statutory power of the mining right itself. In this video, we will focus more on the majority judgment while sharing some light on the minority judgment. Let us now look at the court's determination. 1. Mining right versus lease agreement. The question was whether a mining right gave the holder thereof access to the property to which that right pertains in the absence of the landowner's consent, that is, without a valid lease. The court found that the lease agreement between the parties is the basis for cooperation between the municipality and ZNH. Therefore, ZNH and Stonewell could not simply ignore the lease and rely on the mining right alone to access the property. The minority judgment found that Section 5(3) of the MPRDA confers some limited rights to the right holder, including occupation of the property subject to the mining right. Cession of lease rights. Whether ZNH needed the municipality's written consent for Stonewell to take over ZNH's lease agreement. The municipality argued that because they didn't consent to Stonewell taking over ZNH's lease agreement, Stonewell was an illegal occupant. The court disagreed, explaining that contractual rights can generally be freely ceded unless the contract forbids it or the rights are delectus persona, that is, the parties intended that the holder of the right alone should be entitled to it, or contract is so personal in character that it would make a reasonable or substantial difference to the other party. In the present case, the court determined that neither the lease agreement nor the settlement agreement precludes the cession of the rights ZNH enjoyed under the lease agreement. The court reasoned further that 1. Stonewell intended to use the property for the same purpose envisioned in the lease, namely the exploitation of a mining right. 2. The lease agreement was inextricably linked to the converted mining right, which was now held by Stonewell. And 3. The option to renew the lease is directly linked to the renewal of the mining right. 3. Tacit cession. Whether Stonewell was entitled to exercise the option to renew the lease. The court held that the minister granted the consent to the transfer of the mining right from ZNH to Stonewell. This meant that Stonewell acquired all the rights previously held by ZNH, including, by extension, the rights that flow from the lease agreement with the municipality. The court reasoned that although there is no written cession of the lease agreement between ZNH and Stonewell, such a cession can be tacit or inferred from their conduct, namely Stonewell's purchase of ZNH shares and the subsequent cession of the mining right from ZNH to Stonewell. From this, the court ruled that ZNH tacitly ceded its rights under the lease agreement.
4. Requirement for ratification. The municipality relied on Regulation 34 of Municipal Asset Transfer Regulations, which requires public participation for municipal assets, and Clause 15.4 of the lease agreement, which stated that renewal option was subject to municipal council ratification if required by law. The court rejected the argument, holding that Clause 15.4 of the lease agreement does not give the municipality a general veto power. It only applies if a law actually mandates ratification. It also held that Regulation 34 only applies to assets valued over 10 million rand, which the municipality never alleged or proved. Finally, under the regulation, only the municipal council can authorize the public participation process. The municipality cannot rely on its own failure to authorize the process as an excuse to invalidate the lease extension. The minority judgment also dismissed the municipal argument, calling the complaint convenient and contrived to facilitate the sale of the property. She held that the owner's consent was obtained 10 years prior and that the municipality's conduct unlawfully frustrated the objects of the MPRDA. 5. Section 54 not applicable. This section is often cited as a remedy for access disputes. The court found that Section 54 did not apply, holding that Section 54 is only triggered when a miner is prevented from commencing or conducting mining. In the present case, Stonewell was already occupying the site and mining. The jurisdictional requirements for Section 54 were not met. In the minority judgment, Bartman also found that the municipal reliance on Section 54 is misplaced for reasons that the municipality has been aware of the mining right for 10 years and had cooperated with its exercise. Further, the municipality and Z&H had litigated issues pertaining to the mining right and have reached a settlement in respect of their differences. 6. Sale of property. The court rejected the municipal reason for declining to extend the lease, namely that it intended to sell the property. The court was blunt. The sale of property is legally irrelevant to the validity of a mining right. Under South African law, a buyer takes the land subject to existing mining rights. You cannot evict a miner just because you wish to dispose of the property. In summary, Zincede against Matatiele reinforces 3 hard truths for the industry. When a landowner and a miner enter a lease, that agreement becomes the basis for cooperation. It cannot be ignored by either party. Mining rights generally survive the sale of the underlying land. Where agreement does not preclude sale without consent or is delectus personae, a tacit cession of the agreement to the new entity can be inferred. For emerging miners and landowners alike, this case underscores the necessity of aligning your lease agreements with your Section 11 transfer processes. Key takeaways. Coexistence of rights. Landowners and mining right holders must exercise their rights alongside each other reasonably. Neither party's rights are absolute. Cooperation is required. Mining operations require cooperation between the landowner and mining right holder, often regulated through agreements such as leases. Lease agreements matter. A mining right holder cannot ignore a lease agreement and rely only on the mining right. Likewise, a landowner cannot ignore the agreement and rely only on landownership. Lease rights can be transferred. Lease rights linked to a mining right may transfer with the mining right without the consent of the landowner unless the agreement prohibits it or the rights are personal in nature. Tacit cession is recognized. A lease transfer doesn't always need to be in writing. It can be inferred from the conduct of the parties. Ministerial consent controls transfers. Transfer of a mining right requires consent from the Minister of the Department of Mineral and Petroleum Resources, not the landowner.
Sale of property does not cancel mining rights. A property is sold subject to existing mining rights. A mining right holder cannot be evicted simply because the owner wants to sell the land.
That brings us to the end of today's video. Thank you for joining the SAminingDesk, where mining law is clarified and simplified so that we may all participate in the exploration of our common heritage, mineral resources. If you found this useful, subscribe, like, and engage in the comments. Until next time, take care.